So what do you do if a tenant dies and all of their personal property is still in the apartment or that rental dwelling? Well, the Nebraska Landlord Tenant Act has a provision that landlords can use in their lease agreement to help with that very issue, and it can be an issue. We're going to talk about that in this video. Hey everyone, if we've never met, my name is Paul Vojchehoske and welcome to Nebraska Landlords YouTube channel, where my mission is simple. That's to enhance the landlord-tenant relationship through education. We're continuing our series going piece by piece over the Nebraska Landlord Tenant Act. And today we're going to deal with Nebraska Revised Statute 761414. And basically this part of the statute covers two things. Number one, what can a landlord put in a lease agreement? And number two is, what happens if a tenant dies? There are some things that the landlord can do to deal with that tenant's personal property when they die in that rental unit. So first of all, if you get any value out of any of these videos, please do me a favor. Give this video a thumbs up, hit that red subscribe button, click on the notification bell. All right, so I got them on your screen right here. The first three things that Nebraska Revised Statute 761414 does is, number one, it allows the landlord to include certain terms and conditions within their lease agreement as long as those terms and conditions, they're not prohibited in another part of the statute. All right, so let me give you an example. It is very common for landlords to put provisions in their lease agreements that deal with modifications to the property, prohibiting a tenant from painting or not allowing a tenant to put up decorations during the holidays, or who is responsible for trash removal, who is responsible to shovel the walks, who is responsible to mow the lawn, those type of things. So as long as those terms and conditions don't aren't specifically prohibited in another part of the landlord-tenant law or in a law such as fair housing, the landlord can do it. A landlord does not have to demand rent. So they don't have to go knock on the door and say, hey, Mr. and Mrs. Tenant, rent is due, please pay me. It's assumed under the law that the rent is due on the due date, and the tenant's responsibility is to pay it. There is no demand feature here, unlike other states where there is a feature, a demand feature is what we call it. The other thing is, this is interesting, is the rent is due and payable at the actual unit that's being rented unless the lease states otherwise. So that's why it's very common in lease agreements, the landlord is going to put the address and location of where the tenant is required to make the monthly rent payment. Now, absent that requirement or that provision in the lease agreement, technically the tenant could say, hey, your lease agreement, Mr. Landlord, doesn't include where I'm to pay it. So under this provision, under this statute citation, you need to come and pick it up from me. So make sure that the location of that of where the rent is to be paid is included in that lease agreement. Number three, the landlord, they don't have to have a fixed expiration. The 1414 allows the landlord to either one, have a fixed expiration lease agreement, or number two, they can have a month-to-month lease agreement, or in the case of a roomer, which is someone who is renting out, let's say, a bedroom in your home that you live in, they call those roomers, it can be week to week. There are some states that don't allow, for example, a month-to-month or a roomer weekly type relationship. It's only fixed expiration. In Nebraska, it's pretty much whatever the landlord-tenant agreed to in the lease agreement. However, absent a fixed expiration, then it automatically defaults to a month-to-month. And what happens is, what we see a lot of times is, let's say that there is a fixed expiration, it's a one-year lease, but the tenant stays and the landlord doesn't want them to move, then it automatically, that lease agreement automatically reverts to a month-to-month. Now, all the same terms and conditions remain, but the requirement to end tenancy changes to a month-to-month. So anyways, that's just a little bit of tidbit that's in there that I think is interesting. All right, next I want to talk about what happens in the case of the death of the tenant. Now, this was a great change to the statute because Believe it or not, this actually benefits not only the landlord, but also the tenant as well, because we want the tenant's estate to be able to recover and retrieve their personal belongings. So what the Landlord Tenant Statute did is built in a provision where the landlord can require that the tenant provide an authorized person to retrieve the personal property from the tenant who has passed away. So then after that, the statute outlines the requirements that the landlord must follow. So first of all, the landlord can require you and say, hey, listen, if you're going to rent this property, then I need an authorized person. So give me a name and a telephone number. And by the way, landlord, you have a right to contact that person to verify that they're real and that the number given is actually to that person. That's the first thing. Number two is the landlord can require the tenant, let's say every 6 months, to update and verify that authorized person or change the authorized person and their contact information. So landlords, don't forget to do that. It's really important that you do. All right, so now we have the procedural part of it once an authorized person has been established within the lease contract. Now let's look at bullet point number 2. If the tenant dies, the landlord must make reasonable attempts to contact that person within 10 days after being notified of the tenant's death. Now, there's only one attempt that's actually required under the statute. However, landlords, please make sure that you document the date and the time that your attempt was made to contact that authorized person and any subsequent attempts to do that. Now, the 10 days, that's so important. Please document, landlords, please document when you were notified and how you were notified of the tenant's death, okay? Because that's what starts that 10-day clock a-ticking. Let's look at bullet point number 3. The authorized person then has 20 days after notification by the landlord to retrieve that tenant's personal property from the unit or wherever that personal property is stored. Landlords, you are authorized if the tenant dies to move their personal property out of the unit and then put it in a safe, secured location so you can get that property re-rented, etc. You don't have to, but that is an option that you have. In either event, the authorized person has 20 days from notification to retrieve that personal property or decline. That authorized person could say, I don't want nothing to do with it. In either case, they have 20 days after notification. So the other thing to remember is if the authorized person doesn't respond after 20 days, then that 20-day requirement has expired, and then the landlord has some things, which we're going to talk about in a minute, that they have to do. All right, let's talk about the authorized persons. Now, number one, if that authorized person does show up to retrieve that tenant's personal property, landlords and managers, please make sure that that authorized person shows you a government-issued ID. That is required by statute. Make sure you make a copy of that for the file. All right, make a copy of that. Even if you take your phone and do a snapshot, either way, we want to make sure that we get a copy of that. Goods. All right, next bullet point, personal property not taken by the authorized persons must be disposed of in accordance with the Disposition of Personal Property Act. Now, contrary to popular belief, that authorized person doesn't have to take a thing. It's not one of those things where the landlord can say, if you're going to take that item, you have to take it all. That's not how it works. The authorized person can actually pick and choose which personal property of the tenant they want, and whatever's left over, then the landlord or manager must dispose of that property in accordance with the Disposition of Personal Property Act, which is a different video that we're going to talk about because there is also a strict statutory procedure for disposing of a tenant's personal property. The good thing is there is a built-in hold harmless clause. So let's say the authorized person takes all the electronics. Well, at that point, once they take it, then the landlord is no longer responsible for anything that happens with that property. They're held harmless. Now, landlords, please make sure that you not only, in addition to making a copy of the authorized person's valid government issued ID, but please make sure that you inventory the items that authorized person is taking. If the landlord is unable to contact that authorized person after 20 days is up, all that personal property then must be disposed of and handled under or in accordance with the Disposition of Personal Property Act. Again, that's for a different video, and you have to follow that strict procedure. Folks, stay informed. It is so important to stay informed. Learn how to do that by clicking the little video right here. Also, don't forget to subscribe. Click the little circle to my left. Comments and questions down below. Join our email newsletter. It's down below. The link is for the landing page. Stay informed. That's all I have. See you in the next video.